In episode 26 of the Borman Lawyers Court Report show, we take a look at a low-range drink driving offence we appeared on at the Downing Centre local court in the Sydney CBD.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. They say it ain't no way. I ain't never listened, kept them at the distance. This is for the ones who ain't afraid. And this is more than a paper chase. I wonder who else could say the same.
G'day, it's Josh Borman here from Borman Lawyers. I'm just standing out the front of the Downing Centre local court in the Sydney CBD. That's that building just behind me with the yellow trimming on it. Today I appeared on a low-range PCA or drink driving offence where the blood alcohol reading was 0.077. In New South Wales, the low-range category is between 0.05 and 0.08. So at 0.077, my client was certainly at the top end of the low-range category. We put a lot of prep into this case in regards to getting some really good references. We got one from our client's wife, his mother-in-law, a work colleague. We also put a lengthy and strong letter of apology to the court from our client. He works in banking. He was concerned that a conviction would affect his employment going forward, but that was secondary to the concerns he had about losing his licence for 3 months, since he is the main driver of his family unit, since his wife doesn't drive. He does have 2 young children. He does care for his mother-in-law, who does have health problems. So these are all very real concerns that we put before the court today. On the night of the offence, when he was caught, he had gone over to a friend's place. He had made plans to drive into the city to have dinner with a friend. However, those plans had been cancelled at the last minute. However, at the time he was over at another friend's place over at Ermington. My client lives at Waverley, and he was pulled over for the purpose of a stationary random breath test in Redfern. So that was one big issue that the magistrate today got caught up on, was the fact that between where he was at Ermington to where he was driving to his place at Waverley, and pulled over at Redfern, there was quite a significant distance that he had driven that night, whilst he was obviously under the influence of alcohol. Aside from that, there were no other significant aggravating features involved. He was the only person in the car. It was a random breath test. It was quite late at night, so there was minimal traffic on the road, but the magistrate did get caught up on the issue that he had driven quite a significant distance, and it wasn't just down the road to the local shops or anything. So the level of risk to having an accident or causing injury or harm to someone was heightened due to the fact that he had driven quite a significant distance. So that was one issue that the magistrate had concerns over. The other big issue for our client was his traffic record. It was the first drink driving offence he's ever been involved with, but over a period of about 20 years, he does have about 15 entries on his record, albeit relatively minor infringements, except for a couple of high range speed. And in the last 5 to 10 years, he did have a lot better record with only a couple of entries. However, his prior track record was not unblemished. There were quite a lot of entries there, and certainly that didn't work in his favour either. We did get our client to go along to a traffic offenders program. This certainly worked in our client's favour. It showed that he has taken positive steps to rehabilitate, re-educate himself on driver safety. Today we were pushing for a Section 10(1)B, which is a good behaviour bond without recording a conviction and no disqualification. Unfortunately, the magistrate wasn't of the view that he was going to give a Section 10 today. He did make comments before the court that the case couldn't be more prepared. Me as a solicitor couldn't have said anything else on the client's behalf, but the thing that he did really get caught up on was the fact that the blood alcohol reading was at the higher end of the low range category at 0.077, and he had driven quite a significant distance on the night before being pulled over. They're the 2 big issues that he got caught up on. At the end of the day, he didn't give a Section 10. He did disqualify our client for a reduced period from the automatic period of 6 months. He reduced it down to the minimum period that the court can give of 3 months, starting from today. He also issued our client with a $500 fine. So it wasn't the holy grail of pleas of guilty that we were after. It wasn't the Section 10. We have been before many other magistrates before, with even higher readings and probably more serious offences, and we have gotten plenty of Section 10s before in those circumstances. However, the magistrate we got today, every magistrate's different. They deal with it on a case-by-case basis. He did get caught up on those 2 issues. Mind you, he did say there's nothing else that our client could have done in the way of preparation or oral submissions to the court that could have changed his view that he wasn't going to give a Section 10 today. So we did put our client's best foot forward. We got the second best result with a full reduction from the automatic period of 6 months down to the minimum period of 3 months, and a heavily reduced fine from $1,100 down to $500. So our client was prepared for the fact that he may lose his license today, and he understood, he accepted the reasons that the court gave and the penalties that they handed down. So this is just another drink driving matter that we have appeared on at the Downing Centre local court in the Sydney CBD. We appear here quite regularly. This court behind me, the Downing Centre, it is the busiest courthouse in Australia. It's obviously probably the busiest city in Australia, but for that matter, it is a matter which has a large it is a court which has a large number of magistrates. It has a high volume of matters which go through it every day, and often some people can get very swamped and overwhelmed if they appear by themselves at court. If you need to appear before a court in either Queensland, New South Wales, around Sydney, Brisbane, Gold Coast, we appear in all both jurisdictions and all the courts around those main cities. If you'd like to give me a call on 1300 941 900, I can certainly have a chat to you about your matter, see what we can do for you, and what you can what you're going to be looking at, what you can expect from the court. Alternatively, go along to our website, which is Boorman Lawyers, BOORMAN lawyers.com.au. We publish plenty of information there. There's blog posts, there's articles, there's information on laws, penalties, offences. There's more videos like this one there, statistics, a heap of information there on all sorts of offences which you may have found yourself caught up in, and you can read up to make yourself a bit more familiar with the situation you might be in. And again, you're more than welcome to call me to clarify anything you want, and see how we can best represent you when your matter comes before the court. Thanks for tuning in today, guys.